very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, today we are back with this weekly legal current affairs for the month of January, part 4. In this session, we shall be discussing, deliberating about certain very important recent legal events that has taken place over the last 1 week. Now, as a student who is preparing for CLAT, ALIT, and other law entrance examination. Now, other law entrance examination includes Maharashtra CET and others, right? Symbiosis and all. So, in this session today, we shall be specifically talking about certain very important legal developments. For example, certain important appointments, certain important legal judgments coming from the High Court, Supreme Court of India, which are important insofar as your preparation for CLAT and other law entrance examination is concerned. So with this, we begin with the legal current affairs, the weekly legal current affairs, which all of you are eagerly waiting for. Let's see the agenda for today. The first, coming from the Supreme Court of India. A division bench of the Supreme Court of India has held that if a person is tried for the same offense, now suppose there is an allegation of theft against Mr. A, and subsequently another FIR is lodged against the same person about the same incident, can he be punished? There is a principle of double jeopardy which operates under the law. We have constitutional provision which bars the court from punishing an individual twice for the same offense. Let's see what the Supreme Court had to say. That's the first judgment I'm going to talk about. The second one is right to be forgotten. Now, there are a number of cases, right? Suppose there is a case against me. There is a case against Mr. A. There is a judgment. Now, how long can people see that judgment? Now, all the judgments are right now open in the internet. Each and every one of you can see every judgment. Now, suppose there is a divorce case. For example, I'll just give you an example. Mr. A and Miss B. Now, suppose there is a dispute between a husband and a wife. For how long can that judgment be on the internet? Do we have a right to be forgotten? Because social media, as you know, today brings up something which has happened 20 years back, and there is a media rage on it. We are going to talk about that. The third important is an appointment. New Delhi Arbitration Center. Justice Hemant Gupta has been appointed as the chairperson of the New Delhi Arbitration Center by the Union Cabinet. And finally, we are also going to touch upon a very important issue relating to partnership. Death of one partner. Suppose there is a partnership. Whether the death of one partner, does it foreclose the continuation of a civil proceeding? Now, suppose there is a civil proceeding between a partnership firm and another party. Now, just because a partner of that particular partnership has died, does it foreclose the continuation of the civil proceeding? We are going to discuss these 4 important things in detail. But before that, BYJU'S Exam Prep brings to you a free workshop, Key Learning from CLAT 2023 on 15th of January at 7 p.m. This free workshop will be conducted by my colleague Nivedita Raji, a legal expert. So she is going to conduct this workshop. Please join Do get yourself registered for it so that you can participate in this free workshop about what are those learnings that we have done. We had to learn from CLAT 2023. CLAT 2023 was just less than a month back, right? Okay. So, and thereafter, many congratulations to Anika Sehgal, our 1-year online classroom program student, for securing AIR 18 in ALIT 2023. I'm moving on. The first important judgment coming from the Supreme Court of India. The Supreme Court of India says that there is a bar, there is a prohibition, there is a restraint. When? Where is that restraint? This restraint deals with situation in an offense. Now, suppose there is a criminal case against a particular individual. He has been tried by the court of competent jurisdiction. Now, can another case be instituted based on the same factual situation? Now, suppose a person has been acquitted or convicted of an offense which was tried by a court of competent jurisdiction. Now, based on the same facts, based on the same action, can another case be instituted? What does the law say? Now, let's see. Now, the Supreme Court has said that Section 300 of the CRPC bars a trial of a person for the same offense. There is a bar on the trial of a same person for the same offense. Now, that's called the principle of double jeopardy. Now, if a person who has already been tried by a court of competent jurisdiction for an offense, either been acquitted or convicted, he cannot be tried again for the same offense. He cannot be. Is that clear? Now, there is this constitutional principle which is embodied under Article 20 to Article 22, which says that no person shall be prosecuted or punished for the same offense more than once. So once an individual has been tried, whether he is acquitted, whether he is convicted, that's a separate question altogether. The question that we have to answer right now is, can another trial take place on the same factual situation? The answer is no. There is a protection against double jeopardy. It is supplemented by Section 300 of CRPC. Section 300 of CRPC also takes the same thing, that no person can be punished twice. Even Section 40 of the Indian Evidence Act talks about the same thing. Not only the Constitution, the CRPC as well as the Indian Evidence Act also deals with situation wherein a person cannot be punished twice for the same offense. Let's see what the judge had to say. Justice B.V. Nagaratna. The appellant herein was earlier charged for offense under Section 13(1)(c), read with Section 13(2) of the Act, and Section some, so and so. So here a person was charged under certain provisions of the law. He was convicted in 2 cases and acquitted in 1 case. So there were 3 cases against him. He is convicted in 2 cases, acquitted in 1. Present 2 case arises out of same facts, same transaction, and that in the previous 3 cases where the appellant was tried and convicted or acquitted respectively, for an offense to be considered of the same offense as the last offense, it is necessary to show that the offense are not distinct and the ingredients of the offense are identical. Previously charged as well as the present charge, it is for the same period of misappropriation. So this was a case relating to Prevention of Corruption Act. So here was a government person who was charged under certain provisions of the Prevention of Corruption Act. Now, there were 3 cases against him. He was convicted for 2 and acquitted for 1. Now, later on, can he be prosecuted for the case in which he was acquitted? The answer is no. 3 cases. The present case are the same and are said to be committed in the course of the same transaction while holding the one and the same post of agricultural officer by the appellate. So there was certain corruption charge against this public servant. The Supreme Court categorically says you cannot file a case right now and charge him, put him on trial for what he has been acquitted, because it is based on the same facts and situation. The judge said the concept of double jeopardy can also be understood in terms of Article 21 of the Indian Constitution, which says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Life under Article 21 of the Constitution is not merely the physical act of breathing. It does not connote mere animal existence or continued degree throughout the life. It has as much wider connotation. It includes the right to live with human dignity. In the celebrated judgment in the case of Maneka Gandhi versus Union of India, this court gave a new dimension to Article 21, wherein it is stated that the right to live includes within the ambit the right to live with dignity. So right to live, a right to life as enshrined under Article 21 cannot be confined to just right to breathe. No. Right to live like a human being, right to live with dignity, human dignity. Under the umbrella of Article 21, various rights like right to free legal aid, right to speedy trial, right to fair trial have been included. Similarly, protection against double jeopardy is also included under the scope of Article 21 of the Indian Constitution. Now, very, very important. Prosecuting a person for the same offense in same series of facts for which he was previously either acquitted or has been convicted and undergone the punishment affects the person's right to live with dignity. Very, very important. I want each and every one of you to understand and read this particular passage, because you might get in your CLAT examination, you might get a passage on this also. Right? Everyone? Is that clear? Everyone? Every one of you. Okay? Now, Justice Nagaratna further says that the court further explained the difference between double jeopardy is often confused with double punishment. Double punishment may arise when a person is convicted for 2 or more offenses charged in one indictment. So, if a person has committed theft once, he is punished. Again, he commits theft, he can be punished again. That is double punishment. But double jeopardy means on the same facts, you cannot punish that person again and again and again. This doctrine is certainly not a protection to the individual from peril of second sentence of punishment, nor to the service of a sentence of one offense, but is a protection against double jeopardy for the same offense, against a second trial for the same offense. So, on the same offense, you cannot put a person on trial again and again and again. Is that clear? Okay. So, that was the first judgment. Further, in this particular case, Justice Nagaratna also held that it has already been observed herein above that the allegation of offense in the instant case are the same as the allegation in the previous 3 cases. Therefore, as per the mandate of section 300 subclause 2, the consent of the state government is necessary. Even if it is assumed for a sake of argument that the allegations are different, in present case, those from the previous case, the prosecution has failed to obtain the prior consent of the state government, which is necessary to prosecute the appellant. or the person who is before the court. Therefore, the trial in the instant case was or is unlawful. So, under the Prevention of Corruption Act, to prosecute a government servant, you have to get the prior permission of this government, state government or the central government. Such thing was not done in this present case. Since in the present case such a thing was not done, the Supreme Court said that this case itself, the institution of this case itself, is unlawful. Okay, am I clear, everyone? Okay, moving on. Next important judgment, right to be forgotten, from the Kerala High Court. Now, all judgments that are delivered by the court, especially the High Court and the Supreme Court, they are all published. You can go to the Supreme Court website, check on every judgment. You can go to the every High Court website, check on every judgment. Now, there is a freedom of speech and expression also involved. Right. Now, matrimonial dispute. Now, suppose there is a dispute between a husband and a wife. Should the world at large know about it? Now, there is a lot of debate, intellectual debate on the same. Now, the question very categorically here is, suppose there is a case against Mr. A, which was, say, suppose 20 years back. And the judgment is there on the internet today. All judgments are there on the internet. Now, after 20 years, he has reformed. Now, tomorrow someone picks up that judgment which was 20 year back and says that, oh, you know, this man is a thief. Now, every man should be given that right to life, right to be respected, right to hold a life with dignity. Now, the Kerala High Court has said that right to publish judgment is a constitutional right, right to publish judgment. Now, you have various medias which are uploading judgments because it is freely found on the internet. Now, reporting and publishing of judgment is a part of freedom of press. Now, if tomorrow there is a very important judgment, for example, a Sabrimala judgment, for example, gay rights judgment, for example, NCT versus the power of the central government insofar as the Delhi government is concerned, those judgments, those are important judgments. So, no, those judgments are required to be published. There is no doubt about it. But at the same time, should certain category of judgment be there for life? Especially what I personally believe is matrimonial disputes. Disputes relating to husband and wife. I don't think the world at large has a right to know what happened between the husband and the wife. There is a divorce. There's a marriage. What happened? Why did it happen? What did the judge ask? Now, you have to have an open court system. I agree. But to what extent? Now, can there be a rape trial openly? Now, if there is suppose a person has been raped, a woman has been raped, a lady has been raped. Now, can the trial be open to media? Tomorrow, the media will be there, and you know, everyone is a journalist today with a phone in their hand. Everyone has a phone with a camera which can record anything. Now, today we have to ask all these questions. Now, the Kerala High Court has said that the claim for the protection of personal information based on right to privacy cannot coexist in a open court justice system. Now, if you say tomorrow that I have right to privacy, now right to privacy more or less goes once a case goes to the court, because there will be lawyers, there will be judges, there will be persons from the media, and the judgments will be uploaded on the internet. Now, based on this particular fact, what do we see? Now, the Kerala High Court said that right to be forgotten cannot be claimed in the current proceeding or in a proceeding of recent origin, and the legislature should fix grounds for the invocation of such right. Now, the Kerala High Court, very diplomatically, I would say, stated very clearly that, whether there is a right to be forgotten is to be determined by the legislature and not by the courts. So it has left this question open for the legislature, for the lawmakers to decide what should be the grounds that a person can say that, I have a right to be forgotten. Supreme Court, the Kerala High Court said that, in this particular case, we are not getting into it. But if the legislature decides, okay. So it has left the question of right to be forgotten left open for the legislature to decide. Very important. The court, having regard to the facts and circumstances of the case during innovative related to crime and other litigation, may permit a party to invoke the above rights to de-index or to remove the personal information of a party. Now, I'll tell you this. Now, suppose there is a particular actor or an actress, a Bollywood celebrity, somebody who is famous. Suppose he goes to the court. Now, in the court, what happens? You have to give your residential address. You have to give your Aadhaar card number. Now, problem arises. If it is given, left open for everyone, then anybody can get your residential address, may get your phone number even. If tomorrow, for example, Shah Rukh Khan files a case in a court, he has to give his residential address, his age, his Aadhaar number, everything in detail. Who is he? Now, his phone number. Now, should people of the country be allowed to know every personal information about those individual who has gone to court? That's a bit larger question. The court said that those can be permitted to be deleted. The court, in appropriate case, is also entitled to invoke principles relating to right to ensure to allow a party to erase or delete personal data that is available online. So the court is at liberty. The court is at liberty to delete certain personal data, to erase certain personal data about a particular individual which is available online. Am I clear? The court held that in family and matrimonial cases arising from the family court jurisdiction, where the law does not recognize open court system, the registry of the court shall not publish personal information of the parties. Very good. And shall not allow any form of publication contained the identity of the parties on their website or any information maintained by the court if the parties or to such litigation so insist. Now, the court said very categorically that, in matrimonial cases, which is not an open court system, in those cases, if the party comes to the court and says that my name should not be, given too much in the court order, then the court can say, okay, personal information about a particular party can be deleted, can be erased for that purpose. The registry of the High Court is bound to publish privacy notice on its website in both English and vernacular languages. So, if there is a case in the court, it does not amount to violation of right to privacy. Now, if there is a Bollywood star, the superstar goes for a divorce, those are highlighted cases. We have seen some of them happening in the court. So, all those personal information need not be disclosed. The interplay of providing information about the party and providing information on the context of the cause in a court of law requires a balancing exercise. It is exactly that exercise that has to be considered by the court, and these writ petition in the abeyance of any legislation. Anonymity through a different form, privacy, It becomes a facet of privacy when the cause and content of a case are identified with the parties in the list. The privacy aspect of such information about the identity of the parties cannot be separated from the cause that is being considered by the open court, transparent court proceeding. So the court very categorically stated that the moment a case comes to the court, it is an open court system. Anonymity is something too distant to think about. The judge further says, in family and matrimonial cases arising from the family court and jurisdiction otherwise, and also in other cases where the law does not recognize open court system, the registry of the court shall not publish personal information. So, cases relating to matrimonial dispute, the court should not, the registry of the court will not publish personal information and shall not allow any form of publication or containing the identity of the parties in their website, because that anonymity must exist. Emphasizing on freedom of speech expression of the publisher, the court said the courtroom is open to all. Court cannot gloss over the protection available to publisher of judgment under Article 19(1)(a) of the Constitution. Reporting and publishing judgment are part of freedom of speech expression and cannot be taken away lightly without the law. Now, suppose there is a law, only if there is a law which says that publication of a particular judgment cannot take place, fair thought. But in the absence of such a law, how can a judgment not be published? That is what the Kerala High Court had to say relating to right to be forgotten. The court also said that the judgment forming part of the court records are public documents under Section 74 of the Indian Evidence Act. There cannot be any dispute in regards to publishing the contents of the judgment, even if such judgments are ordered to be masked in regard. Now, you can mask it. Now, suppose there is a judgment relating to Miss Pooja Agarwal versus Savitri Agarwal. So, you can mask those. You can say XXX versus YYY. That can be done. So, that is called masking. That is called masking. Masking the identity of the parties. We have already overruled the right to claim privacy in public sphere in open court system. The courtroom is open to all. Now, in an open court system, you cannot claim privacy. At max, you can say my name should not be there. You can just strike it off by XXX versus YYY. That's at max. Okay. Moving on to the third important legal development. Former judge of the Supreme Court of India, Justice Hemant Gupta, has been appointed as the chairperson of the New Delhi International Arbitration Center. The central government has appointed former judge of the Supreme Court of India as the chairperson of the New Delhi International Arbitration Center. So, Justice Hemant Gupta, former judge of the Supreme Court, Justice Hemant Gupta, is the chairperson of the New Delhi International Arbitration Center. He was a judge who gave the split judgment in the hijab ban. He stated that secularism is applicable to all citizens. Therefore, permitting one religious community to wear their religious symbol would be antithesis to secularism. It's a split judgment. It is referred to a larger bench. Okay. Moving on. Before we move on to the next important legal development, BYJU'S Exam Prep brings to you CLAT 2024 Comprehensive Course. Secure a seat at your dream NLU by joining the CLAT 2024 Comprehensive Course. We will provide you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law entrance examination with video solution, monthly e-magazine for current affairs, and contents are all based on the last 5 years of CLAT paper. There are limited seats. Do get yourself enrolled for this comprehensive course. Now, about the New Delhi International Arbitration Center. Now, it was established in 2019. It was declared as an institute of national importance. Now, in the regime of institutional arbitration, it was established as a center where international arbitration can take place. Now, it is responsible for conducting arbitration, mediation, and conciliation proceeding in Delhi. Okay, so the New Delhi International Arbitration Center is an institution in itself, wherein Justice Hemant Gupta has been recently appointed as its chairman. Now, its responsibility is to conduct arbitration, international disputes can be resolved without entering the court in an amicable manner by way of arbitration, mediation, or conciliation. The other members of the New Delhi International Arbitration Center are Ganesh Chandru and Anand Vijay Patel. Now, very recently in the news, we had heard about the New Delhi International Arbitration Center. The bill was introduced in August 2022. It amends the New Delhi International Arbitration Center, and it says that it will be renamed as India International Arbitration Center. So the bill renames the New Delhi International Arbitration Center as India International Arbitration Center. So today what we have as New Delhi International Arbitration Center, it will be called, after the bill becomes an act, it will be called India International Arbitration Center. Am I clear? It shall be referred to as India International Arbitration Center. So this was a bill just to change the name of this arbitration institution. Am I clear, everyone? The fourth important legal development coming from the Supreme Court. Death of one partner does not foreclose the continuation of a civil proceeding initiated by a firm. Now, in a partnership firm, we are talking about a partnership firm. Suppose there are A, B, C, D, E are partners. There's a civil proceeding against a particular another party. Now, if one of the parties, one of the member or one of the partner of the partnership firm, if he or she dies, does it foreclose the continuation of a civil proceeding? The Supreme Court says no. When two persons have sued in the name of a partnership firm, if one of such person dies during the pendency of the proceeding, it is not necessary to join the legal representative of the deceased as the parties to such proceeding shall continue in accordance with law. Now, suppose there are 5 partners in a partnership firm, 5 partners, and one of the partner dies. Now, just because one of the partner dies, does it mean that you have to bring the legal representative on record? Legal heirs? No. The proceeding can continue. There is no difficulty about it. It is categorically stated that it cannot be said to have held the suit would stand abated in the event of the death of one of the partners, where the partnership firm comprises of 2 partners. What this court has observed is that where one of the several partners dies in the name of the partnership firm as compared to one of the 2 partners of a partnership firm dies, the decree is granted would not be executable even if the partnership firm succeeds in the suit. Is that clear? Now, there are certain procedure of law, Rule 4, Order 30, which deals with right to sue on death of a partner. At this stage, I don't want to get into it too much, but the Indian Contract Act as well as the Civil Procedure Code very categorically states that if one of the partners in a partnership firm dies, and suppose there is a suit, a civil suit that is pending in the court, just because one of the partners died doesn't mean that the suit abates, suit dies off. No, nothing. So friends, BYJU'S Exam Prep brings to you a free workshop on key learnings from CLAT 2023, which shall be conducted by my colleague Nivedita Raje on 15th of January at 7 p.m. Do get yourself registered for it and join it. So we have certain procedure of civil law. We have certain procedure of civil law which categorically bars abatement of a civil proceeding in the case, in the event a partner in a partnership firm dies. So guys, with this we come to the end of this session. If you guys have any doubt whatsoever, please let me know. Please let me know. Any doubts whatsoever. Any doubts whatsoever, guys. Any doubts whatsoever. So guys, I am sure that you guys were able to understand this particular session well. You guys understood the important things that I have spoken and discussed with you about. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great evening ahead. Have a great week ahead. Bye-bye. Take care. Good night. Bye-bye.